What's up, everybody? Sorry I'm late. I don't even know what it looks like here. Haven't checked anything. Bedtime went a little slower than usual, but we made it. We're here, and it is a wild, wild day to discuss, and we have to today. We haven't done much of this throughout the Brooks trial, but we have to today actually watch some of this trial together. So I'm going to start today's video off by giving a really brief rundown of some of the highlights of the day. And then we are going to watch what everybody is talking about, and that's the temper tantrum thrown by Darrell Brooks, by the defendant in this case, the arguments with the judge, how the judge handled it. And I also want to highlight the response by the state and by the judge, because I think that's really important. And we've had some people in the chat, in the subscriber base here, asking really smart and really good questions about, wow, some of that actually makes some sense. And I think the judge and the state slammed the door shut on a lot of the nonsense that he argues. But I do think that this is yet another opportunity for us to recognize Darrell Brooks is not a dumb person. He is not. He makes these arguments sound like they make sense, even though they very, very, very clearly do not. And we're going to break that down tonight. And at the end of the video, we are going to watch together, because there's been a lot of discussion about that Nicholas Cruz Parkland shooting case and that verdict, about it being one holdout juror. We're going to watch a short clip of the jury foreman to give us a little more insight about what happened into that jury room. I think it's only 3 minutes long. And we're going to watch that together because there's a lot to talk about there as well. That'll be at the very end. Okay, let's get to it here. So there were issues with the subpoenas. Actually, before we get there, I almost forgot. And Azam reminded me. Thank you, Azam. We went from 139K to 140 in 2 days. We're positively growing. Let's get to 150K here. Hit that subscribe button if you haven't already. You all are the best. If you don't hit that like button, I think Leslie P. will ask for grounds as to why you haven't hit that button yet. You know, give me some grounds. Give me some reasons. If you guys want to join the membership crew with Martha, and I think there was one other one in here that I can't see. Melanie wants us to break 2.3K in the stream tonight. Hopefully we can do that. There's a lot to talk about. A lot to talk about. All right. So there are problems with the subpoenas. Some people can't be here till Monday. He doesn't really fight about it. He's coming in, starting the day. He's pretty calm. He's pretty balanced. He doesn't consent to the name. He says he means no respect, but he does say that he filed his name change with the Secretary of State or something like that, and the judge hasn't bothered to look it up and call him by the right name. The judge basically tells him, if you don't stop this craziness with the plaintiff and a lot of these questions, she may be forced to give the jury a curative instruction. What a curative instruction is basically telling the jury, disregard the crazy comments he's making because they are not legitimate. They are not something that you can take into consideration. So when he says these certain things and it seems like he's making a point, he's actually not, and you should disregard them. That is damning. You don't want the judge to tell the jury to disregard things that you say. That's bad. It doesn't take a lawyer to figure that out. The first witness, which was the dancing granny's witness, the arguments over the objections were much worse today. It was not just grounds, as ASAD 311 says. There was a lot more arguing. He was a lot more argumentative and disrespectful toward the judge today. Right from the jump, you could tell. He's objecting with no reasoning, and then the judge is overruling it with no reasoning, which is kind of interesting. Not making the prosecutors argue. And then when he keeps asking for grounds for her determinations, it's funny. I wrote in my notes, I'm like, she does not have to give you grounds, dude. She doesn't have to tell you why she's overruling. That's a rule of law. She doesn't say. You are the one supposed to make the argument. And he doesn't make the proper argument. He doesn't understand that. He's not a lawyer. We'll get to that more later. But then she almost gets baited into it and starts giving him reasoning, saying it's not relevant. Relevance, hearsay, outside the scope, whatever. She starts giving him reasonings for why she's overruling his objections. It's almost like when a kid tells you, I can get you to say blue, right? And it's like, what color is this? It's red. What color is that? It's red. What color is this? It's red. What color is the sky? Blue. And you say blue. It almost feels like that kind of a trick that Darrell Brooks played on the judge, because she actually did start to give him some reasoning, which is pretty wild to think about. It really is wild. He did a much better job objecting to leading questions today. There were some that were absolute leading. He objected, and the judge sustained a few. She let a few go again, which wasn't great, but nothing was that big of a deal, I didn't think. Then he continues to interrupt the judge, butting in, and the judge basically has had enough, and you could tell. And when he cross-examines this witness, who I thought was very damning for him, she was so nice. She was kind of shocked when she watched the video, and he's literally rolling his eyes as she is shocked watching her friends get hit by a car driven by this dude. He's rolling his eyes. The jury can see this. If I can see it, the jury can see it. In cross, he stands up. You're questioning this nice old golden gal, and he's standing up while cross-examining her. She can't hear him, poor lady. She's like, I can't hear you. I don't know if it was the mask because he was too far away from the mic because he was standing up. She hadn't seen the videos before today. He was going to try to make it seem like she was acting. He was asking if people were giving her diagnoses. She's like, sir, I don't think that's how it works. I don't think they diagnose people laying in the street. He's like, well, how did you know what was wrong with them? She was like, sir, she was laying on the ground face first with blood everywhere. I knew that she didn't make it. If you're a juror, can you wait to convict this guy at this point? That's what it feels like. It feels like he's literally digging his own grave with how he's acting towards some of these victims and spectators that were there. He's like, you wanted to testify. She's like, no, I thought that, like, when you give a statement to the police, if they need you to testify during trial, that's how it works, and you come and testify during trial. Then he starts going through the list of people that were not injured, as if that's going to be a great argument. And then he starts getting into it with the judge. And the reason I wanted to give that brief recap before is he was getting angry and annoyed. That is why I think he started fighting with the judge. And I think that's kind of what started the spiral. But let's take a look here and watch some of this together so we can really get the full feel of exactly what went wrong today for Darrell Brooks and how it looked to the jury. A lot of this arguing before the judge was in front of the jury. Obviously, they're walking out when he gives his 50-minute speech. We will listen to some of that. I may kick up the speed to make it more my kind of speed, 1.5 to 2 times speed, something like that. We'll take a couple breaks. I'll answer some questions as I usually do. But I really want to listen to some of this to hear his argument so you can know exactly what he's doing. And we're going to listen to the state respond. We're going to listen to the judge respond. And we'll talk about how all of this works and why the judge doesn't interrupt. So let's get into it here.
Are you aware what a plaintiff is? Grounds.
Sustained.
Grounds for sustained, Your Honor.
Next question, Mr. Brooks.
All right, this is
sustained, Your Honor.
Ask you now.
all right. This is on 2 times speed. We're going to try this together. Okay. If a lot of you hate it, let me know. I will drop it down to 1.5, but that's as slow as I'm going to go because I want to get through as much of this as I can, and I don't have 3 hours tonight to hang. I do have about an hour, so a little longer than the last couple nights. We're going to hang for an hour, so let's get through as much of this as we can together.
Next question, please.
I just want to know the grounds, just for the record, grounds for the sustained.
Yeah, write 1.5 if you want 1.5 speed, and I'll kick it down. Let me know. If enough people, if we get 10, 20 people asking for 1.5, we'll drop it down.
Ask your next question.
Your Honor, the grounds should be put on the record.
Ask your next question. I'll address this all at the next break outside the presence of the jury. Ask your next question.
She's
Your Honor,
begging him to let her protect him from the jury seeing him look like he's throwing a temper tantrum. She's begging him.
The jury
Mr. Brooks, under
deserves.
90611, ask your next question, or I will determine that the cross-examination is now closed.
I'm
Keep
going to keep going. I just think the jury deserves to.
Mr. Brooks, I'm instructing you to stop making those statements. The jury will disregard. This is the cross-examination. It's not your opportunity to make legal arguments or to testify. You'll have an opportunity if you so choose to do that later.
But all respect,
Next
that is not
question.
justifying. The jury just deserves to know.
All right, number 90611, the cross-examination
still
will
have
be
a question,
determined.
Your Honor.
Sir, you didn't follow my very clear instructions. Does the state have any follow-up? All right, thank you, ma'am. You may step
Objection
down.
to that, Your Honor.
Your objection's noted. Ma'am, you
I
may
was
step
not-
down, and after she steps down, I will be excusing the jury for a few moments. Please rise for the witness and for the jury.
All right, jury's going out, and we're dropping it down to 1.5. The people have spoken. Let's get to 1.5 speed here.
As they leave the courtroom.
Yeah, a lot of you watch it today also. That's why I was thinking 2 times speed, but that's okay. That's okay. We'll do 1.5. And we'll get through as much of it as we possibly can together. I've got some time
Mr. Brooks,
stamps
please wait.
for when the state comes in.
You may have a seat, everyone. To specifically address the repeated request by Mr. Brooks for the court to state the grounds, sir, I am not legally required to do that. Those are legal determinations that if you feel there is an error later on, you can address on appeal if you are convicted. I have been answering many of them at your request, but I may not do that at all times. In fact, you're asking me to provide that explanation and really highlight for the jury the court's opinion on relevance. That's why we don't state that. There's an objection. It's a party makes it, states the grounds. Sometimes I ask the opposing party for their position. Sometimes I do not. Many times it's very self-evident. Either the objections are baseless. Many of the hearsay objections are baseless. Your objection to hearsay is it's not hearsay. So that's why to me they're self-evident. I say sustain and we go forward. So you need to be aware, sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury, which I don't feel is necessary for the reasons that I've already stated, that you're asking me to highlight my opinion on relevance and my determination on relevance. So going forward, you need to be aware of that. Again, not a sign of disrespect. It's the record is self-evident. Many.
Yeah, when he keeps saying, well, let the record reflect, or I need to say this for the record, she's like, bro, everything gets typed down. Whether you ask for it to get typed down or not, everything gets typed down. I do want to give a quick shout out to some Scramble partners today, Todd Utter and Tim Sullivan in the chat here. Todd asked if we won the Scramble. I don't know. I didn't stay long enough to turn in the card, but we probably did because that's usually what happens when we enter Scrambles. So yeah, the judge said what I've been thinking all along. You don't have to give him those that reasoning. She also goes into what 90611 is, which I find really interesting. So let's keep listening.
If I feel that more argument is needed, I'll excuse the jury, but I haven't felt the need to do that up until this point. And I will caution you once again, sir, 90611 is the statute, mode and order of interrogation and presentation controlled by the judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. A, make the interrogation and presentation effective for the ascertainment of the truth. B, avoid needless consumption of time. C, protect witnesses from harassment or undue embarrassment.
Okay, so protect the needless waste of time and protect the witnesses from harassment and embarrassment. And a lot of you asked, why is she allowing this? Why isn't she cutting it off? She's got to stop this witness. He's badgering these witnesses. It's being horrible. It's just been horrible for these witnesses. How is she allowing it? Listen, as horrible as it is for the guy that hit your family member with his car on purpose to ask you questions, if he does it respectfully, that's what the law protects. But when he starts to go off like this and he starts to waste everybody's time and he starts to harass people, that's when the judge can cut him off. And that is what the rule says. And I think that is what's really important for everybody to hear as we learn this process and as people understand why is he getting cut off. Some people are on both sides of this, right? Some people say he shouldn't even be able to speak. Other people are saying the judge should never cut him off because of his constitutional rights. This is where the line gets crossed, and that's when she's allowed to cut him off. I think she's been very respectful and slow to cut him off. She could have cut him off. I mean, a less patient judge would have cut him off a long time ago, in my opinion.
And it goes on, but for purposes of what I'm going through, that's the most relevant portion of 90611. So when I give you the warning that under 90611, I will cut off your cross-examination, it's because you're violating 90611.
And so a judicial determination that I violated 90611 when
I'm advising you, sir, It's not a specific determination as to anything that's happened thus far, just a summary of why I am relying upon 906.11 throughout the questioning of witnesses and the presentation of evidence.
Your Honor,
So with that, we're going to continue. I'm going to have the state be ready with their next witness.
Your Honor,
She wishes they were about to continue after that. I'm going to go through some of the new members here. If you want to join the membership of the channel, we do some members only chats and videos sometimes. It's in the video description. You can hit join there and do that if you want. I'm going to go through some of these and some of the funnier ones or more interesting ones here like this as we listen to him. Darrell Brooks, the floor is yours, sir. Let's have a listen to what he has to say and why he thinks this is an illegitimate proceeding. You're going to learn a lot about sovereign citizens and about what he's trying to do right now.
I'm not interrupting you. I'm letting you make a clear record.
Mr. Brooks, you have actually interrupted me.
I just let you go through the whole citing of 906.11 without saying anything.
I'm not asking for the parties to make an argument under 906.11.
So
I'm
why
advising you. Stop interrupting me, please. I'm advising you.
Yeah, brother, you don't let the judge do anything. She lets you speak. She lets the lawyers speak. We don't let judges speak. We just sit there and we wait till it's our turn and we ask the judge if we can speak. That's how it works.
Sir, so that you have hopefully more knowledge and awareness as it relates to the statute that I've cited dozens of times during this trial.
I'm well aware of what I'm citing, Your Honor. Well aware.
All right, so
and I'm just seeking for the record to be clear. With all due respect, Your Honor, that's judicial misconduct because you're not allowing the jury who deserves to hear certain aspects of testimony.
It's no small thing to accuse a judge of judicial misconduct. Okay, I just want to highlight that. It's not normal. That doesn't happen in most trials.
Like I stated yesterday, under the Sixth Amendment, I have the right to face my accuser, which means that I can question about clearly the plaintiff being the accuser. How come I can't question about if a witness may know or have had any prior interactions or any conversations or anything of the sort with the plaintiff who has yet to show their face? Also, the reason why I was objecting the way I was is because I was trying to get to the question of the witness saying that about the four ladies in her group that were not injured. There's relevancy because with her stating on the record, clearly for the record, and for Your Honor, and for the court and for the jury that these ladies were not injured in any way, but yet there's still charges associated with these ladies who were not injured. That should be dismissed.
We are not at that point, sir. The charges I read refer you to the preliminary jury instructions for first-degree recklessly endangering safety and the elements they don't.
To me, honestly, like right here, even I can't believe a ton of new members tonight. I don't know if we've had this many members join in a single video in a long time. So that's cool. But she's giving him too much, in my opinion. She eventually just lets him speak. I would have just let him speak here because you're not going to reason with him. It's not going to be something that he's going to understand and agree with.
Need to prove there's certain elements. And so I'm not going to have a debate with you over the law at this point. I've made my rulings as it relates to certain questions that you have asked and whether they're relevant, whether they're vague, whether they call for speculation or a whole host of reasons that a question can be objected to. I'm not further going to address your position on.
May I request a legal reconsideration of the ruling, Your Honor?
You interrupted me. I'm not done with what I was trying to say.
There was no way for me to know that because you paused. I'm sorry. I apologize.
Just because I paused doesn't mean I'm done.
But you paused for quite a while, so I wasn't sure.
In any event, sir, we're going to keep.
Like, dude, he's losing it now. He's just arguing with her way too much. Steve, curative instructions would not shut Brooks up. Curative instructions would be telling the jury to basically disregard what he's saying. And we'll talk a little bit later if we get time. He started saying things under his breath that were just despicable while some of these people were on the stand.
Going, any error you believe I've made, you can raise again on appeal if you are convicted, but we will proceed forward. Does the state have the next witness available? Please do not interrupt. I'm asking a second question.
That's why I was
Mr. Brooks, you're interrupting. Stop. Does the state have available their next witness?
We do, but could we please request a comfort break, Your Honor? I'm sorry, but we have been going about 2 hours now.
All right, that's
As long
fine.
as
We'll
they're
take
out.
a 15-minute break. That's fine.
Gonna regret that. So they go on a little break here. And then when we come back from the break is when we really get it.
Is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to.
I think I missed the part where
that
All rise.
this court has subject matter jurisdiction.
Here we go.
And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later. if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please,
military
can you
power?
please take the jury out? Thank you.
So let me pause here again. When the jury is walking up, they don't just stay in one spot, right? When the judge says bring the jury back, they are moved and they are brought to a specific spot. They know they're about to enter the courtroom. So when they get to that spot and the judge sends them away again, they know something has happened. They know something has happened. And in this case, it's Brooks going off. The judge has to send them back out. The jury knows that this is not going smoothly. Okay, they're not stupid. They're not in a little bubble like we all like to think they are. They know stuff's happening.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will. I will.
Thank you. Everyone else can be, you all can be seated. Mr. Brooks, just make your
Thanks,
statement.
Wanda.
You
Welcome.
do want to advise the court today.
Floor
I
is
wanna
yours,
first
buddy.
state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking, is
And on what
this,
legal basis are you making that request?
I'm asking for the record, is this a common law court or an admiralty court? What are we in here?
The words you're saying, sir, are technically legal terms. They don't make any sense in the context that you're using them.
I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office.
He thinks he's important enough for people to like commit crimes with fake oaths of office, like the judge would do that and lose her license and lose her job. And John, I'm with you. It's the only way.
That is based on the fact that I have the right
this.
to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is. I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021, the amended complaint from November, anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my.
Hey, this channel calls him pro per all the time. You guys always call him pro per in the chat, right? We show respect in here, even though we have no clue what the difference is because there really isn't a difference.
Defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brought to my housing unit on the 29th of September, which trial was scheduled. That would be a Thursday.
So keep track of all the stuff he's complaining of. And if you remember back, we listened to part of the hearing when he decided to go pro se and get rid of his lawyers and some of the colloquy and the questions the judge asked him to make sure he understood exactly what he was giving up and why it's a better deal to keep a lawyer. Keep that in mind as we listen to all the complaints he's about to make right now. And yes, it's wild. 3,300 people watching. This is the biggest stream we've had in a few months. So that's awesome. If you guys are new, hit that subscribe button. You won't regret it. Hit that like button on the video. Let's get people in here. If they want to talk about what happened in the Darrell Brooks trial today, we're doing it here and we're doing it live and we're answering questions because it was wild.
Trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well
That is just not true. You know that's not true.
aware that I was not prepared. I raised the issue that it should be an adjournment, at least. At the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor?
Yes, dude. She knows those answers.
Can anyone
we
right
all
now
do that
in
practice
court,
law.
anyone make a claim against me?
Yes. State of Wisconsin.
And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter. So who makes the claim?
There's 66 injured parties that the state makes the claim on behalf of, dude. Like, it's so frustrating. It's so frustrating to hear him go on and on and on like this. Yeah, Rachel, I was wondering if the judge was going to kick him to another courtroom too. I wouldn't have hated it so she could mute him. But she's doing everything she can to protect his rights. And I do understand that. I do understand that. But sometimes you got to give people what they're asking for. And he is asking for it. Loud and clear.
Just for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining to those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own. And then when I did that, correction still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case?
It's actually the same thing, dude. It's not just one thing. It's the same thing. It's the same thing because it's something that you don't understand. Kaylee, I don't read anything into it like she's trying to put him in his place or be disrespectful. Even the state said, like, we've been here for 2 hours. We need a comfort break. The judge is sitting there in a chair for a long time, too. I actually see when she gets up sometimes. She pulls one of those. I do, too, like to stretch your back. That's kind of what it seems like to me more than anything else.
That this docket sheet is inaccurate. Every filing,
it's because it's not
up
certified.
to the point that I started representing myself, was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here.
We know, dude. We know.
Gives more credibility to the venue needing to be changed.
All right, so here we go. Here's where he talks about where he talks about venue, and he goes through all these things that he thinks is so unfair right now.
Describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be.
Not Bill. No, not at all. And you'll hear what the state says and what the judge says. This has been tried many times before and failed.
Awarded the time to work on this case, seeing as how I only had a couple of days to prepare for a trial of this magnitude. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still
we're going to watch this. Okay, Par, we're going to watch this together.
There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here.
Brittany B., I got to be honest with you. There's zero chance I would have let him go on for 50 minutes. I probably would have given him 10 minutes and be like, you've had 10 minutes. That's enough. Maybe I would even give him a warning. You got 5 more minutes. So whatever your most important arguments are, make them now so we can move on. No way I would have given him 50 minutes, but I understand what she's doing. She's trying to show the appellate court she let this guy do everything he wanted to do throughout the trial to give him a fair trial. Krista, it gives you, the confrontation clause gives you the right to confront the witnesses against you. For you or your lawyers to cross-examine the witnesses against you and hold the state to their high burden of beyond a reasonable doubt in proving the crime against you. It does not give you the right to make dead people take the stand that you have killed or are accused of killing for obvious reasons.
Here in the city of Waukesha, which gives more credibility to the venue needing to be changed. Yet and still, that was denied.
Assad, same, dude. Same.
It's impossible for impartial jury to be found in this county, and that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That would be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is that I have children too, family too, loved ones too, that also have been ridiculed and had their names drugged to the mud and have threats towards them. Loved ones that had to leave their home because they were getting threats thrown through their mailbox. Children that didn't.
And that sucks, and that's terrible, and that shouldn't happen to his loved ones. Does he think he has any part in that? In that his actions or what he's accused of doing potentially has any part in that as well? And this isn't just an accusation that there's, it's random and we could go either way. Like, there's a video he did it. Maybe it was an accident. Maybe he didn't mean to. But, I mean, he was really blaming everybody else here for his circumstances as if he had nothing to do with them.
You feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever.
Always, John. Always, man.
And report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy, definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive and it's not true. I'm sure the court read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions. I think it was obvious that the venue should have been changed. Obvious.
And you disagree with the court's ruling. That's fine.
It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero. There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction.
He goes back to that. He's got to go back to
no
jurisdiction.
bond on file in the docket sheet. We still have no plaintiff. We still have no claim.
Dana, we're about to hear the state say the same exact thing.
Of the relationship between you, Your Honor, and a father of one of the people that was injured.
And I mean, that's legitimate. If that's legit, but again, this is why this is like the boy who cried wolf, right? We're bringing all sorts of old stories into this. If you say a million things and one of them is true, that truth can be lost in all the million lies that you tell. But if she's connected to a victim, which I highly doubt she is, or she would have recused herself, I promise you she didn't want to be the judge on this case for obvious reasons. But that's a legitimate gripe. If he thinks she has a connection to a victim, she shouldn't be the judge. So just file a motion with that. It's easy.
Relationship, no matter how well prepared the speech was, because it was a prepared speech, that was obvious.
He's saying when she said that she did not have a relationship with the victim or with a victim's family member, she's like, that was a prepared speech, which was obvious as he reads his speech off of a piece of paper.
I just asked that same question. Can the affidavit be given that
not at all,
there's
Christine.
No bias, no conflict of interest, and no interest in the outcome of this case? There's no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 50 minutes to
seriously. Thank you.
Arguments.
Thank
You've now repeated yourself a number of times. So I'm going to turn to the state to see if they have any response.
Yes, they do. Almost 4,000 people in this chat. It was a wild day for the Brooks trial. Hit that subscribe button because we're giving these breakdowns and recaps every night, talking about Brooks. Tomorrow night, there may be some scheduling issues. We have to do a little earlier. We may talk about it over the weekend, but make sure you hit that subscribe button, ring that bell, and like this video. If you're here and you're new from Brooks, let me know in the comments. Let me know if you guys are new subs from the Brooks trial. Yes, celebrity entertainment, it was wild.
Thank you, Judge.
Let's hear the state, though. This
Judge,
is
I'm going
good.
to summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190. I'm so sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states The majority of Retzlaff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo. Sovereign citizen theories are frivolous and wholly without merit. The court goes on to cite to Bay, B-E-Y, versus the state of Indiana at 847, Fed 3rd, 559, on pages 559 through 560, a Seventh Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly.
You call that name, nor do I know any individual by that name, Your Honor.
No, dude,
Courtesy,
not your
not
time.
interrupting the state, as they did not interrupt you for over the almost 50 minutes that you spoke. Thank you. Please
Seriously.
continue.
Your Honor, the record is very clear that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial.
Boom.
He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today: the resources of the
Literally.
state, the knowledge of the law, his ignorance of the law. And his words to
Exactly.
this court, and I quote to the best of my ability, "It don't make me flinch one bit." That's
Exactly. He wasn't scared. He can handle this. He's smart. We know that. It doesn't make him flinch. Assad, he doesn't know. He doesn't know what he's talked to some other sovereign citizens, and he's trying to do what they, are telling him to do, or coaching him up, or, show the world what we believe in, kind of
what
thing
he
is what
told
it
this
feels
court.
like.
whatever it was 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know, because unfortunately I was talking to my investigator if he accused this court of treason, but I certainly heard that word come out of his mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful of his rights at every turn, at every turn. I want to address this claim that he only had 3 days to prepare for trial. It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder of the witness who's testifying and effectively cross-examines that witness using notes from the public defender. We know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions.
We have kind of thought that, right? We talked through that. Some of this makes sense. Some of this feels like it was prepared. I didn't know if it was from a depo or from his lawyer. She's saying he's reading his lawyer's questions, and then we can tell when it switches to the Brooks questions, right? You see the plaintiff in the room. Is there subject matter jurisdiction? Did you file any claims? Do you have a financial interest in this case?
Having to do with his belief in the sovereign citizen movement. There's no way this record would reflect that this defendant is not adequately prepared for trial. He's never asked for a speedy trial. He makes conflicting statements. On one hand, you violated his rights because it's taken us so long to get to trial. And on the other hand, we're rushing him to this case, and he hasn't had adequate time to prepare. He is not denied access to legal materials in the jail. The record is very clear from the jail administrator. It should not be confused. He misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. He has access to a tablet. He has access to a computer. Whether he chooses to ask for those resources is up to him. I would also cite the court to U.S. ex-rel George versus Lane, L-A-N-E, Seventh Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal about his lack of access to a computerized legal research system, paralegal training, or law school education. The court rejected that contention and said, once a defendant has asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him. And he basically acted as if you were insulting him and said it didn't make him flinch one bit. Much of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials.
Yeah, see, she's saying he's reading from a typewritten transcript. So he's reading these sovereign type speeches that somebody has prepared for him. which makes sense.
materials. But he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Objection to that. Your Honor, that's a load of crap.
This is my opportunity now. I gave you about 50 minutes.
I just want to object to the
That's a load of
disrespectful
crap.
comments that was just made. I'm not trying to
He wants to say they're disrespectful as he calls what they said a load of crap.
hold you up from what you're gonna say, but that's a load of crap.
Mr.
For her to sit there,
Mr. Brooks,
for her to sit
your
there,
objection is noted.
for her to sit there, Your Honor.
It's my turn. Let me go through this. I graciously
you.
gave you
Thank
50
you.
minutes to raise all these various points that you want to bring up. I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility. I did not interrupt you. The state did not interrupt you. Your objection to their characterization, it's noted for the record. I'm going to render a decision at this point. Please listen, and please do not interrupt.
Do it.
As
Do
I
it to
indicated,
him.
the defendant spoke for about 50 minutes, raising a litany of complaints and issues and theories regarding his view of how this case has proceeded. Many of these issues, if not the vast majority or even all of them, have already been addressed by this court in one way or the other. Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion. The court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest that this is a biased jury. I stand behind my previous determination and the process that this court went through, including initially calling an unusually large panel for which the clerk of court's office sent the initial qualification questionnaire, and then ultimately a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors.
This is a wild process. When she explains the extra steps they took during jury selection, including 10 preemptory strikes.
There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained. Even prior to that specific hearing, the parties met, they conferred. The state agreed not to challenge the vast majority of the challenges to jurors brought by the defense. And then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then even on the day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which many of those Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot.
Camila, you'd be surprised how many defendants that end up in this situation are really impressive in portions, and you think that about them. If they would have dedicated this to good, it could have been really good. Instead, this is what we get.
Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive, they come to this court. As the case law says, there's a presumption that they come to the court without bias. And it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law and fact. There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining, I should say, or overruling objections, for an example. There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no different why the case law is very clear. You can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable, but to follow criminal procedure, the rules of evidence. That is what circumscribes the rights that a defendant or the state has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further. The fact that you now are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear. The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of.
All right, we don't need to get into this again, but I do want to take a second and get to Diana B., who said at the end of the day, he gave kind of a scary look. Let's take a look at it here. I think it's at 10:37-ish. After the jury's out, this is the look he gives the judge. That's the look he's given the judge, who has really been more gracious than he deserves and has given him more time than he deserves, more camera time, more face time, more ability to speak and explain things and make sure he gets things on the record and makes his objections heard and makes everybody understand where he's coming from and the problems he has with this. Being a sovereign, as Nil said, which I think will be stopped in closing if he really digs too deep. Sparkling Dragon said she paid for a super chat. Didn't go through. I apologize. Try it again. The chat is a little wild tonight. I'm trying to keep up. There's a lot going on. My Bell, have a hard time feeling sorry for this guy. I love her channel. Yeah, I agree. I mean, I try to give everyone the benefit of the doubt, the presumption of innocence, and that's where we're at this point. And he's presumed innocent basically because the trial's not over yet, and that's about it. I mean, this is a tough one. Mel Mitch, the judge and prosecutors will be exhausted when this is over. You can't even imagine how brutal it is. Des Escientes, what would happen if a witness just totally lost it on Brooks and openly insulted or threatened him? Threat would be bad, and that could be different things because there's problems with threats. But if they just insulted him, he could say, oh, look how biased they are against me, basically, and the judge would admonish the witness probably. What is it with Sovsits objecting to the form of how their name is formatted? This is a common objection. I've heard the Sovsit videos. I don't know. I'm not a Sovsit expert, and it just is. It's a wild way of thinking. Buckingham, lawyer, you know, I'm a new sub. Your channel was mentioned in a number of the times in the Law and Crime chat when it was live. Lots of regulars recommended me. Awesome. That's awesome. Well, I'm glad that you're here. How is he in contact with other Sovsits, Lindsay said. I don't know. Maybe in the jail system? I don't know. In the jail system, they could be asking other people and giving him stuff. I'm not really sure. And Lindsay is also a new member. That's fun. It is commentating gold. American Rose Designs interlocutory appeal is like an appeal that you do right now. You don't have to wait till the case is over. Sometimes something happens in the case. You have to appeal it right away. Tons of new members tonight. Tons, which is a lot of fun. I figured it out. The chat was moving so fast. Yeah, I think I did get to it. I've gotten to a couple of yours, but the chat is moving tonight. It's moving. A friend of mine said that's the same look he had when he was driving. Scary. It's really scary. It's not. That's what they call not a good look. Janelle, just wanted to say hi. Your coverage of this trial and the Rust cases brought me here. Can't wait to hear you take on DB's antics today. It was insane. It was not a normal day in court. It was not a normal day in court. Why isn't he in contempt? Because the judge is trying to be gracious. The judge is trying to give him a fair trial. And that's why he hasn't been thrown in another courtroom at this point. Sierra, 1897 is the year that Bel Air Country Club was started. Been around since 1897. I think one of the oldest in Florida. Martha Sazanowski, what is a tacit agreement? I think it's like, you're not telling me you agree with me, but you do, so I'm going to take that as a yes. I think it's kind of like that. I'm not positive. I've never heard it used in court. Peter, do you think that she's giving him reasons to the jury so that the jury knows why she is objecting? The judge doesn't object. That's the point. The judge usually doesn't want to give reasoning, so the jury doesn't think like, oh, that was a stupid question, or oh, that was speculation. They just say overruled or sustained, so the jury doesn't really pay attention to objections. We don't want to bring a lot of highlights to these objections because we may be losing or stuff may be inadmissible. That's not really the point of objections, is not to bring the jury into it. Mo, at what point does he cross the line of re-traumatizing his victims? I feel like he is getting too much leeway on some of these witnesses. Some of them, but the judge is shutting it down, and that's the 90611 rule she's citing. If she feels he gets there, that's where she crosses the line. Sheila, is his behavior going to impact his eventual sentence if he's found guilty? I'm pretty sure he's getting multiple life sentences if he's found guilty either way. Sue, Peter, look up the website Social Blade and look at your channel. Your numbers are impressive. Congratulations. Thank you, Sue. I'm going to write that down. Social Blade. I am so not up with the YouTube stuff and like the social media stuff. So you guys probably know more about it than I do. So this is cool when you tell me something like that. Leslie P. But then there's some things I can't explain. Explain the whole name thing, the third party representing his client. He is a third party intervener. The name thing, I think he's just trying to be difficult. Some people told me he changed his name to a rap name. Some people told me it's because it's in all caps. Some people told me because they never asked him to consent to being called that name, that he doesn't like being called the defendant. There's a bunch of different reasons potentially why the name is thing. The name thing is a thing, but I'm not positive. There's no legal reason I can think of. Heather Forder, just wait until he starts talking about how disrespected and bullied he's been. I know. Saying other people are disrespecting him. Other people are making threats. It's like, do you know what you're accused of doing? Much worse than threats. A little off topic, but how can he claim to be a sovereign citizen and then claim he has constitutional rights? It's a sovereign citizen of the United States. The constitutional rights he's referencing are the United States Constitution, not the state constitutions. Carsto, Peter, to me, this is a travesty of justice. Why is he allowed to hold court and spew untruths without interruption? It's not right. The judge has tried to calm it down, but it has not been perfect. It has definitely not been perfect. There were some other witnesses that came. The medical examiner came through, and not all judges take copious notes. And it was a pretty brutal witness against him. The pastor, when he took the stand, we've had pastors and priests take the stand, and when they wear their, get-ups, it's like, how can you call this guy a liar? And what was Brooks' strategy with him? To call him a liar. I don't think that went over well. Oh, when the medical examiner went, I thought this was sinking testimony from him. I thought it was huge. I thought it was like another nail in the coffin, basically. And then you can always tell because his demeanor completely changed. He was either crying or sleeping or something. He was very slow and quiet when it came back through. One of the mistakes I think the state made today was they continue to try to bolster some of their witnesses, saying, is what you said 100% the truth? Are you certain things like that, usually you're not allowed to do that. That's usually improper. I am going to try to get to as many of the chats. Mo sent Lindsay here. Thanks, Mo. Mo's an OG. She's a real one. Patty Joe Sloss. Hi, Peter. Florida local and your neighbor and longtime subscriber since the beginning of Depp v. Heard. Love your channel and chat discussion. Thanks for your fair and thorough coverage of this tedious Brooks trial. Thank you so much, Patty Joe. And yes, I am in Florida and I am a real lawyer. I know I don't look like it. We always talk about what do real lawyers look like. I practice law. That is my full-time job. That's why I try to do some YouTube stuff when I can. I am a civil and criminal trial lawyer, but 99% of what I do is civil injury cases, wrongful death, catastrophic injury, car accident type cases. My dad does a ton of criminal defense. I've done some of it in my career. So we have experience in a lot of cases like this. I did prosecute cases on the state attorney's side as well. So I just enjoy breaking down these cases and trying to explain the legal process and answer as many questions as I can. And I always say, if you guys are ever injured or in any issue that you don't know how to deal with an insurance company from a car accident or whatever it may be, reach out to me, lawyeryouknow@gmail.com. Website's tragoslaw.com. Our handles on social media are @tragoslaw. It's as quick as I can do the little, spiel of how I can be a resource to you, to any of you, because we've gotten a lot of clients and a lot of questions and people we can help from YouTube, which is always fun. Beth, nervous for my son-in-law to testify. He's WPD. Before trial started. Now, even more when it's his turn. I pray he can keep his cool once he gets on the stand because this defense is so obnoxious. Your son-in-law is testifying in this trial? Wow. Because he's a police officer, I guess. That's wild. Yeah, I'll say a prayer for him. Keep the nerves calm. Stacy, what is a sovereign citizen? They think that the state doesn't have any jurisdiction over them. Law enforcement can't arrest them. They can't be thrown in jail because nobody has that power. And they're a sovereign being, and they submit only to the laws of the Constitution of the United States. Some of them even differ on that. But basically, they're in this little world that thinks these rules don't apply to them, and they don't have to submit to any of this authority. We've broken it down in depth in other videos about this trial if you want to check out the playlist. I know he's competent to stand trial, but is he really all there? I don't know. Peter's dad is the man. Yes, he is. I bet he would respond if they called him Math Boy. I think that might be the rap name that somebody sent me. Marilyn, ain't that the truth? Oh, Anna said she does address the father of the relationship. Okay, I must have missed that part. And I really want to get to that Parkland juror. So, Crazy Cat Queen. So he's a sob sit. Why not treat him like an enemy combatant and just put him in front of the... yeah, we don't want to do that. DM is a new member. Brian Ailman. The kid-sized figures on the medical examiner's autopsy gutted. Like literally gutted. Ugh. Brutal. Heidi H. As a real lawyer here, and I also a real lawyer here, and I can tell you I've learned a lot watching these videos. Thank you so much, Heidi. There are a few lawyers that come in here, and it's always awesome to get your input as well. So thank you, Heidi. That's a big compliment. I appreciate it. Thrive, Plant Strong is also a new member. It's going to be fun, man. We got a lot of new members. We're going to have to plan a membership chat real quick. Dana, Peter, you're at 140K subscribers. You'll hit 150K soon. How will you celebrate with us? Definitely not dressing as DB. Definitely not. But there will be giveaways, and we will do something fun when we hit 150K. So also follow us on Instagram and Twitter because sometimes we post our giveaways on there at Tragos Law. Peter, can he be made to produce a birth certificate or questioned if he has one? Martha, I don't know what you mean. They have his forms of identification. They have it. Brian, Solution Handyman, can he be thrown out of court? He can be put in another courtroom like he was earlier in the case. House Hippo, if he appeals, will he be able to use a lawyer? Yes, he will be able to use a lawyer if he appeals. That doesn't mean he will use a lawyer, but he could. Will you cover the Harvey Weinstein trial? So I have a trial coming up in a couple weeks, and it's been insanely busy at the office. We're growing, which is an awesome deal, but we are having some growing pains, and we're, keeping up with the staffing and the space and all the things that happen, practice management softwares. So we've been crazy busy. I'm trying to hit what I can. We also covered the Cruz Parkland shooting trial. So we can only hit so many at the same time. I wasn't able to hit Alex Jones at all. So I do appreciate all of the insights always and all of the content requests. So keep them coming, but don't feel offended if I can't get to a case or don't think I'm dodging a case or something. I try to hit what I can. And the ones that are really interesting that you all really come after, that's usually how I pick them. But let's take a second here and let's transition. Parkland shooting trial. A bunch of people, including JB, said there was one holdout juror. It makes sense. And if you just knew they weren't going to change their mind, then why not just come down with the verdict? Well, let's hear if it really was just one holdout juror and what these jurors thought back there while they were deliberating when they came back with a life sentence and not the death penalty. We are a unanimous state. So was it the majority that wanted the death penalty? How strongly did they feel about it? How did they feel about the victims' families? How did they feel about the fallout and the reactions? Let's take a listen to this video.
What do you say about this whole thing, Benjamin?
I don't like how it turned out, but that's how the jury system works.
What were the feelings of the jurors in there? Enough mitigating circumstances?
It really came down to a specific jury that, he was mentally ill, and she didn't believe because he was mentally ill, he should get the death penalty.
How many people felt?
So that's pretty much what the defense was arguing. He's mentally ill and therefore he shouldn't get the death penalty, and it worked with one juror. He didn't like how it turned out. He was the jury foreman, but let's keep listening. There's more context coming here. Sparkling Dragon, no big deal. You don't have to be on Instagram or Twitter. Just we announce more stuff on there as well. Make sure you're in our community page and hit that alert and things like that.
Felt that way of the jury panel?
There was one with a hard no, she couldn't do it. And there was another two that ended up, voting the same way.
So that is a very important statement to me. There was one that was a hard no. She's probably the holdout that we have heard of and we've heard a lot about when it was 11-1 and all that stuff. And when he just finished that, though, he said there were two other that ended up with her. So once it got to 9-3, I think they were pretty confident they weren't going to get a unanimous verdict. I don't think they were going to get a unanimous verdict. I think they knew that. I think they came back with that's why the aggravating factors did not outweigh the mitigating factors. It wasn't just 11-1. It ended up being 9-3. That's why they came back with the verdict. But let's get a little more context.
A lot of people were not in the jury room and all that. It's easy to be critical. What can you say in response to the family saying they're disappointed?
I fully understand. It didn't go the way I would have liked it or the way I voted. But that's how the jury system works. Everybody gets their vote. Everybody gets to decide. We went through all the evidence, and some of the jurors just felt that was the appropriate sentence.
Your feelings about this as a jury foreman that went this way?
Like I said, I didn't vote that way, so I'm not happy with how it worked out. But everybody has the right to decide for themselves. It is a moral decision on their own, and if some of the jurors just felt that way.
How hard was?
I really like this guy. I can see why he was the foreman. I can see why he's picked. He's very thoughtful and he's very convicted in what he believes, but he has room for other people's beliefs and moral values too.
Serving on this jury, the length of time.
Oh, it was awful. It was awful. I mean, things a lot of things you never wanted to see and you never want to see again. It was, don't get me wrong. The people at the courthouse were great. The judge was great. I mean, the lawyers were great. It was just really hard subject matter.
Do you think, does it hurt you that people are being critical of this decision because they were not inside the jury? Does it hurt you?
Everybody has a right to their opinion.
I mean,
like I said, it didn't go.
Even the haters. He even says the haters have right. This is a guy after my own heart. I like this guy.
The way I would have liked, the way I voted, but everybody has the right to their opinion, and that's what happened.
Why did they come back so quickly? Last question. Why did they come back so quickly? It was pretty, there was some people were surprised by why he came back so quickly.
Well, I mean, we had a full day where we went through like that, and then waited overnight for people to sleep on it. And then, if a juror has a hard that they're only going to vote one way, there's nothing else you could do. So we voted and we moved on.
That was really, really interesting. And I give that guy a lot of credit because, you know, some of these jurors go out and do videos, interviews, and they want credit or they want their 15 seconds of fame or whatever. This guy did it right. Pandy Eyes. Question, is the judge in the Cruz trial able to impose death penalty despite recommendation for life? I'm curious if she has the discretion. No, she does not. She can go the other way around. She can go from death to life, but she can't enhance it from life to death. Droon, what does he think he has to gain from representing himself? Does the appeal process just slow down his punishment if convicted? Yeah, but he was going to be able to appeal it anyways, talking about Brooks. He was going to be able to appeal it anyway. So I think he wanted to tell his story to the cameras. That's honestly what I think. All right. I am only 10 minutes longer than I wanted to be. And to me, that feels like a win. I got to absolutely as many questions as I could tonight. Thank you. Thank you. Thank you to all the new people that came, that subscribed, that hit that bell. Stick with us for this wild ride that is the Darrell Brooks trial, because we are going to continue to give recaps and reactions as much as we possibly can to try to see where this case is going and what is going to happen next. So thank you to everybody that joined us. Thank you to everybody that's a new subscriber, that's a new member, tons of new members tonight. And until next time, I appreciate you all. Have a good night.